miss any of those secret words, just send us an email. info@theknowledgegroup.org. The continuing education coordinator will be able to assist. Now, this first question that we do have, Mike, it dropped in during your segment, but it's open to our fellow panelists as well. But Mike, do you have any suggestions for plaintiffs who perhaps wish to bring a claim against an internet platform?
Collection of the key CDA decisions to make sure you know and understand the statute and which claims have survived and why. The second thing is to plead facts that focus on the defendant platform's own speech or content or its non-publishing conduct. And the third thing I would suggest is don't hold back facts the way plaintiffs often do in their complaints and file a threadbare complaint. You are going to get a motion to dismiss on the preemption defense, and it's going to be a tough motion to overcome. So any facts you have based on your investigation showing that the defendant's non-publishing conduct is integral to these illegal conduct occurring, it's a but-for cause or there's a causal relationship, you need to plead those because you may not get a chance to come back and do it again.
Thank you so much, Mike. Another question for yourself, but again, this is open to our other panelists as well. But Mike, do you have any suggestions or perhaps best practice that you can share for companies that are asserting a defense under Section 230?
So, sort of pre-litigation, I think additional services that website companies are adding to their platforms are delivering huge value to their stakeholders, their users on both sides of the platform, their shareholders, and general economy, frankly. But each time a new service is added that's not a traditional publishing service is going to introduce risk to the business, litigation risk, and it's going to diminish the company's chances of successfully knocking out claims under Section 230. So I think it's important to advise the business decision makers of this increased litigation risk so that they understand it. I do think in most instances, the value delivered by the new services likely outweighs the litigation risk, but it's something to be mindful of because you don't want to be surprised where that one service ends up tipping the balancing of the court's analysis in a plaintiff's favor. So that would be the main thing. And then in a litigation context, remember it's an affirmative defense, and don't necessarily get discouraged if a motion to dismiss is not granted based on the allegations in the complaint. All that means is that you have another chance after discovery on summary judgment, and even if summary judgment fails, you can still present that defense to the fact finder at trial. And so you really have 3 bites at the apple in the trial court, and you have a 4th or 5th bite of the apple on post-trial appeal. Well, frankly, even 6 if you count post-trial motions in the trial court. So it's a really, really important tool for negotiating settlements, mitigating your risk, and playing the long game.
Thank you so much, Niall. I want to quickly ask you a question here. This is again open to all of our panelists as well, but it did drop in during your segment. Niall, what are the most common criticisms that you found with respect to the surveys?
That was a good question. So criticisms include anything from constructing the survey in a biased manner. That's a common criticism. And in general, what we do there is we do a lot of pre-testing of a survey to assess whether focus groups and other respondents indicate some bias in a question. We don't want to be leading. That's often a criticism that could really reduce the weight the survey might receive. Generally, I don't see these types of criticisms going to admissibility, but rather to weight.